Let's see. Thanks. All right, counsel, how we doing?
We're doing good. We could just, before you take the jury instructions, just one logistic matter.
Okay.
We're trying to multitask,
All right.
so we want to get out of here.
Excellent.
If it's okay with the court, we have the
Computer.
laptop.
Okay.
Would you allow us to work over there with it? We might be talking just a little bit to because the clerk has the drive, and can we work
Test
over there,
it.
maybe talk a little bit, and
Sure.
then while y'all do the jury instructions?
I'm fine with
Because we
that.
can't leave the clerk won't let us have the evidence.
Oh, yeah, that's right.
We
You can
tried,
have it here.
Right.
right, but we're just trying to multitask.
Yeah, no, that's fine.
No, I
we're
can't
all-
do that accommodation.
That's not a problem, especially when we don't have a jury.
Yes, ma'am.
Your Honor, Mr. Roosevelt, Austin, and I go, we've done justifiable use of force, and we added to the transferred intent. I'm gonna give the court a copy of that.
Okay.
I'd just like to go through the other jury instructions, make sure we're on board with everything, and then if there are any issues when we come back, I'm sorry, Judge, I thought we'd be ready now, but we had to print up one of the printer we have in that room is. I see it, thank you.
I know how it goes. That's why.
I gave the same thing to the state. And here, where we're asking for the battery, just
Okay.
use of force, it will say the felony offense.
Okay, felony offense, okay.
Because in the introduction it says, or
Fel-
commit a felony.
Right.
And so they how they know. And then on the transfer intent, just so you can see what we did is, we added justifiable use of force. Because if you just give transferred intent, you run the risk of having a legally inconsistent verdict.
Right,
So anyway.
that makes
I ran
sense.
that by
Okay,
Mr. Roosevelt.
okay, cool.
We just need a few.
All right, so you took out the provocation altogether. Okay, that's good.
We already talked about it.
Yeah, I think that was appropriate.
It's all right. We will sign it. If you want some, we have a room, the court was getting up to give us a conference room in the back. Yeah, go back there.
Hey, Dino, can you set Matt over here whenever he's done with it? You gotta get the computer done.
I'll get there.
I do not, sir. You need to control this. I do
I
not.
think I just have a battery box. Do that mess over there? Well, it's pretty good to turn on. Hey, Roger,
Check to see what the list shows. You know, if you can get it on your shirt.
Ours are already on it.
Yeah. Yeah, what I just hung up there. Think that. So what do you think? Okay, Matt, you can supervise this. What do you want me to handle? Get it?
Hey, how you doing, Detective? Good. I could turn the mic on. That's all right. We have just a little issue that I want to take care of before. Two of the items were not opened, and I want to go ahead and open them.
Sure.
And just verify that they are what they are before they go back. So,
Be here for an open.
yeah, just,
What are they?
it's number two.
We're gonna find out.
Yeah,
Because it's like Christmas here.
yeah. 2 and 56, was it? Or 1 and 56? 1 and 56? Yeah. Yeah, that's what I wrote down, 1 and 56.
Okay, so one is free flash drive. That's what's in there. And this is biological. Swab. No, it's correct.
Oh, okay.
That's the label. I know which is what.
She is? Did she put her dog down?
Not yet.
Oh,
She hasn't made that decision, but
oh.
if she comes home.
To load all of them, we've got 7, so each one takes 15 minutes, you're talking
So
2.5
it will-
hours.
It will take a few hours by the time we're done with setting up the software and then copying all the drives, because we have multiple, some large
Okay.
files.
So how do we
Yeah.
do that?
Judge, what are your suggestions? I don't know.
Well, we'll have lunch as a buffer, I'm anticipating. Are we gonna be done with
The
closing?
problem is, I'm sorry for interrupting.
That's all right. Go ahead.
The problem is the access to the evidence. If we can't, because we could give it to him tonight, and he could do everything, and in the morning we could all see and all be happy. We will all be happy except for one person.
Right.
The clerk. So that's the problem.
And Detective Smith working
Well,
late.
he'll do that. So otherwise, we're doing it at 8:30 in the morning, and he will be over there during closing arguments. I don't think that's appropriate either. So somehow, we can Can we have a clerk assigned specifically to a room so we can get this done?
I can get a clerk to sit with him.
That work?
As long as it's a clerk in our office, it
Okay.
doesn't matter. So I
No way I can do an order releasing those out of evidence for,
Sure, you can do whatever you want, but we either have to agree.
I don't think that Detective Smith is, maybe we ought to put him under, no, I'm just kidding. I don't think Detective Smith is going to be tampering with our evidence, so I'm not concerned about that. We'll be able to look at the thumb drives after.
do you want me to do that? I mean, otherwise we gotta wait, that's pushing right up to our buffer of
That one, I
lunch.
think the way you suggested, Your Honor, we're okay with. We're gonna be able to see the product anyway on the
Right, you're
computer.
gonna see it.
In the morning, so.
And
you
that's
know.
gonna take some time too, so you'll have to have time to look at it and make sure it's all
Right.
working
And
right.
I'm fine with him
If we
taking
could-
those exhibits, and the exhibits that he's gonna be taking is very simple. It's Exhibits 1.
If I might offer another suggestion, Your Honor, there's no reason that I can't make the changes to the computer that may need to be changed tonight. And if coming in the morning, should be plenty of time to just copy the files. So I've made the changes that I need to make.
Okay.
That will take, that could take like an hour or so.
Okay.
So the copying of the files, if I can get access to them first thing in the morning, I should get off to the side room. There shouldn't be an issue with
Okay,
getting
so
all
that'll
copied.
work.
So let's just get another clerk.
Yeah.
Save it from getting.
Yeah, just get another clerk to be with him in the.
He'll fix it mechanically tonight.
Okay,
And come in the morning,
okay.
sit with the
Okay.
second clerk.
And you can just figure out what password, that you
I'll set a
need.
temporary one, and
For
then I'll
us.
let you guys change it when we come in the morning to whatever it is that you want. and then
Okay.
we can
Yeah.
go from
Okay,
Okay, good.
that's fine.
All right, that'll
That'll
work.
work.
What time are you wanting to start here?
I can be here as early as 7:30. So I'm regularly here by 7:30. That's too early.
I can start here 7:30.
Okay, good.
That has access to the evidence in there.
So Tammy, can
You'll
you,
just tell me what piece, it will not be me, it will be another clerk.
right, but can you just put that in a separate envelope or something? So
Yes.
you just, okay.
Yeah.
The labels show off.
You need all of them?
All right. How about jury instructions?
We got almost all of it done. We just have a couple of things to argue.
Okay,
And then I think they're gonna make the changes depending on how it goes, print out a copy for the court, for the state, for themselves. And we just started the rest of it tonight.
okay, good.
You know what maybe we should have done? Is made a copy of what we talked about for the court, so she knows, she goes through this with us.
You can make an extra copy.
Yeah, you know what I'll do? I'll go upstairs.
Tammy can do it right here.
Oh,
What? The
make
copy?
a copy of this packet here.
Is it stapled?
Okay.
How many?
Just one for me.
We had labels fall off. They're in
Oh.
tax somewhere.
Of course.
It's exhibit, so,
Oh, okay.
I just didn't want to stick my hand on the back.
Oh, he's gonna put it back in.
Just put them right in there.
Probably gonna have to ID this.
Can you just kind of listen? I want to talk to the judge about how we're going to explain to the jury what's going on. We need something.
Yeah.
Judge, part of the discussion, providing the jury with some sort of instruction as far as the use of the computers, so we dummied it down.
Okay,
So we don't know if you want something written, that's read with the record, you want, I'm just spitballing.
I think that if a detective could just write something for each computer, and they can actually take that back with them, maybe we can even, tape it to the computer itself.
Right.
And it's a no-brainer.
right. I think that's the best way, because you can tell them all day long, just like me. I know I was told how to use this thing, but I couldn't, I couldn't remember. I knew there was, so yeah, it's good to have it with,
It's kind of neat looking, I like those arms on
yeah,
the screen.
there's something, all right. So yeah, if he can write something up, and then we can read it into the record and it'll go back with them.
Right, we just tape it,
Perfect.
so they know, so they don't get the two confused.
Right, that too.
Can we talk to, make sure
All right, I have this list of jury instructions.
Yes, Your Honor.
Okay. And we start with 3.1, Intro to Final Instructions. That's about as simple as they get. I always love that one. Never had any argument about that one yet. 3.2, Statement of Charge. Curtis Reeves has been accused of the crimes of murder in the second degree and aggravated battery. Pretty straightforward. Intro to Homicide.
This is from the 2014,
2014 version?
right, that was enacted in 2013 in July, so it was.
In effect?
Yes.
Okay.
In effect,
All right. And
so we're good with that one.
all right, so you've agreed on this one as it is in my hand. The next one is 7.4, murder in the second degree with the statute number underneath. Any issues about all those little semantics or the font or anything?
Well, I think now that we're looking at it, because we have introduction to homicide without a number, either the jury instruction number, I didn't talk this over with Mr. Rosenwasser, but now it struck me, we're gonna have justifiable use of deadly force, it's not gonna have a number or a statute, maybe we can just take all the numbers and statute numbers off and just have it titled murder, second degree, et cetera, et cetera.
That's fine, just so you know, I have some blow-ups. It doesn't, I'm sure it wouldn't matter, I might have 7.7 next to a blow-up, I can't read through the blow-ups, but the jury instructions, I agree, let's just take them off.
Okay, we'll make the instructions uniform. All right. So we got 7.4, murder, second degree. I always love the way these are written. You know, I wish I could keep them uniform. When I'm reading them, it just, first I got that title. I don't usually read the titles either. If I've got a bunch, which I will in this case, they have them, they're going along. So I might, do you want me to read the titles or no? Let's just do it that way.
Just do
Yeah, I
that.
would say read the title.
All right, read the titles. Okay, so I'll read all the titles. And then, but then right the next sentence, they describe it differently. At first, it's murder, second degree, then it's to prove the crime of second degree murder. They do that on a lot of the instructions, but whatever, neither here nor there. All right, so we've got all that filled out. You want to leave that word definitions in there? Fine with me. I always think it's a little informative.
Whatever the defense wants is fine with me.
Yeah, I'm fine with that.
Okay, leaving it in there, okay. Then we've got possession of a firearm and discharge causing great bodily harm or death.
That's the 1020 life language. At the bottom, we're going to be correcting where it says hurt, we're going to be just
Okay.
removing that.
Okay, but you will have A or B, right? Both of those,
Correct.
and it is or. Okay. Then 3.4, lessers, and what do we got?
Manslaughter.
Just manslaughter,
We're not
okay.
requesting any other lessers of that one.
Okay,
The court must give category one.
Right, that's a category, that's the only category one, right?
Yes.
Okay. All right, so then you got the manslaughter, what version is this?
It's the 2021s because, the other one was.
Yeah, yeah. 2021, we haven't had any issues with so far that anybody's aware of? Okay.
And then after, no, go ahead, I'm sorry.
That's all right, go.
It's after, I think the next, it's the next couple.
Okay, aggravation of a felony by carrying a firearm.
You know what? Okay, we need to make a change in that. The first sentence says murder in the second degree, that should say manslaughter.
Right, I
Okay.
saw that.
I remember reading this previously, and I had that marked. Okay. All right. So I'll cross that out, and that'll get fixed. Then justifiable use of deadly force. All right, I see some,
And then what we have to add is an S. So in the second sentence, it's going to say there's offense to the crimes. So there's an S to be added of second-degree murder, and we're going to add and manslaughter.
okay.
And then the thing that I'm asking for, Your Honor, is on the, okay, we'll go to that, deadly force means, still the first paragraph means force likely to cause death or great bodily harm. In the second paragraph down, where the paragraph is referencing a felony, it says resisting an attempt to commit, and it says the offense of battery. We want to insert the word felony because when you look at the introduction says justifiable homicide. The killing of a human being is justifiable homicide, lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant. So the problem with that, without that language, felony of the offense, the felony offense of battery on a person 65 years or older, how is a jury going to know that that is a felony offense? So without that instruction, it doesn't make any sense.
All right. And you disagree?
I always just default to the standard jury instructions. I don't like to change anything. And
I agree.
In the book, it just says in parentheses, any felony, so we just plug in the felony. Otherwise, it would say felony, so I just don't like to change the jury instructions ever.
I agree. I'm with you there, but
The manslaughter one was wrong for a long time. The self-defense was wrong. The
yeah,
battery had
I
the
know.
conjunctive.
This seems to, this is one of those that I think could be okay. It clearly differs from the introduction. I'm gonna allow that. I'm gonna agree with the defense on that, and I'm with you 100%. I'm usually one to run the other way. Don't even talk to me about changing a standard, but these days there's reversals left and right from where judges should have changed something. So
So
I'll
on
do
that
that.
one, we're willing to do the changes on that because we already have that template created.
Okay.
We'll get a copy to everyone.
Okay. Why is the aggravated battery?
That's the argument we're going to have because the imminent commission of an aggravated battery, that's again the introduction in terms of justifiable. In this case, the reason it fits is number one, in terms of jury instructions, that's one of the few places that still recognizes a defendant's rights to in this case, offer a defense. There's the case, let me see. It's been a long 3 weeks, and here it is, Judge. Quoting from Author versus State, 717 Southern 2nd, 193. It's at page 194. They're quoting Bryant v. State and Motley v. State. Bryant at 412 Southern 2nd, 347 and Motley 155, Florida 545. quote, where there is any evidence introduced in trial which supports a theory of defense, the defendant is entitled to have the jury instructed on the law applicable to his theory of defense when he so requests. The defendant is entitled to an instruction on his theory of defense, however flimsy the defense is which supports the theory, or however weak or improbable his testimony may have been, quoting other cases within that paragraph. So in this case, we certainly had testimony regarding how a fist is essentially a deadly weapon, how it can cause fractures, breaks. I mean, we heard the litany from state witnesses as well as defense witnesses, as well as an expert, who's an expert as well, and wasn't qualified as an expert in martial arts, but is certainly familiar with that. And so our contention is that Mr. Oulson was, Mr. Reeves was in the situation where he was protecting himself against the imminent commission of an aggravated battery, with Mr. Oulson's fist being that deadly weapon. And so, you know, we did have some evidence to support that, so we're requesting that part of the instruction.
What change do you want?
Well, we want to put that in. The prosecutor didn't agree with us putting aggravated battery.
Our argument is there was no evidence to support the giving of the aggravated
Oh, okay, I
battery.
gotcha. Yeah.
Well, but here's the deal. They're agreeing that battery on a person 65 years of age or older, so there's an imminent commission of that, right? So potentially he's in position to do that. Well,
That particular paragraph doesn't say imminent commission. That one is
in the commission of
to prevent imminent death or great bodily harm while resisting.
While resisting
So
an
it
attempt.
is just different language.
Yeah.
Judge, if I may just chime in real quickly here. There's two ways to commit an aggravated battery. One is with a deadly weapon. One is by having the amount of damage on that person. We've had, even police officers have come here and said, yeah, you know, a fist can cause great bodily harm. We've had medical examiners say, yeah, a fist can cause great bodily harm. So if in fact Mr. Oulson, if Mr. Reeves was in fear that Mr. Oulson was going to hit him and break his jaw, that would be an aggravated battery. That's the reason that it's an imminent fear of great bodily harm, especially for Mr. Reeves, who has testified that he has been to the medical examiners at least weekly when he was in homicide for 5 years and realized the damage that a fist could do to the human body. And so since there are two ways of committing that aggravated battery, it is very clear that Mr. Reeves' fear would fall within that instruction here.
What's the standard say?
The standard just says applicable forcible felony.
And an
So
aggravated,
it would be up, it depends on the facts of each case.
and an aggravated battery is a forcible felony.
Why can't you put that 65?
Now, that 65 is not a forcible felony.
Oh.
So that's why it's up
Okay,
top,
so it's
because
gotta be a
that says any
forcible-
felony.
Okay, gotcha. So what's state suggesting goes in there?
That paragraph's not given.
Oh,
But it just says forcible felony.
Because that paragraph's only applicable if there's a forcible felony.
okay. I gotcha. Okay. And defense is arguing that,
That there are two ways of committing an aggravated battery. One is with
right,
a,
I know that, the case law that
Oh,
you're
yes.
arguing says that you think that can be inserted here?
Yes, Judge. It's a theory of defense, part of our theory of defense.
And there has to be, let's see, I don't have the, what version of this 3.6F is this?
You're probably looking at the new one that's on the computer.
I am.
Do you want the 14 book?
Is that what you're using, is the 2014?
Yes,
Okay,
yes.
I can pull it up on the computer.
Well, I have it right here, Your Honor.
Okay, yeah.
Do you mind if I just do
No,
it?
that's fine.
What does the language say? I'm sure it's the same, but, you know,
Let me just,
it has to comport with the evidence, I guess.
I have the tab.
I imagine you do.
Well, hang on.
You have notes?
Well, let me just make sure that, you know, I've read in my book.
Did you read that?
Huh?
Okay.
He says it's okay, you probably can't read it this way
Okay.
because of my handwriting.
Chicken scratch. All right, let's see. So that's what that one is. Defendant alleges, okay, so that, though, that's what I was looking for, the little language. And it says, insert and define applicable forcible felony that defendant alleges victim was about to commit. So defendant is alleging that he was about to commit the forcible felony of aggravated battery, and that has to be supported with some evidence. There was some testimony about the possibility of bones breaking. I'm going to allow it. I think it's between the case law and the instruction. I think it needs to be given.
You need that anymore, Judge?
No.
So
And,
after this instruction, then,
You can pass those out too.
you know, is that when
Those
you
are the
read the elements?
proposed.
Right, and so then after that instruction, we would attach battery on person 65 years of age or older. And then we would also, after that, put aggravated battery. So they would go in order, 1, 2, 3.
Where are you talking about?
Right after justifiable use of deadly force.
Oh, okay. Oh, okay.
You have to put the battery,
Right.
65, and aggravated battery.
Right, the definitions, yes. So we got bat 65 and ag bat. That's it, right?
Yes, for
Correct.
that.
Okay, so I see the ag bat in there. We need the bat 65.
No, we need both. The aggravated battery you see is the one that's on Nicole Oulson.
Yes.
Oh,
We'll
okay.
get to that next
Okay,
time.
gotcha. So we need, and those will go right after
Right.
Correct.
that one.
After justifiable use
All
of
right,
deadly.
so we need an egg. The bat 65 will be first because it comes first
Yes.
in the instruction.
Yes.
Okay. And is that all that's the last of the homicide ones and the justifiable use of deadly force? That's it,
Yes, we're
right?
done with the Mr. Olson side of that.
Okay.
I think we're going to the Mrs. Olson.
Okay. All right, and, yes. The, and that's the position that you want them, correct? Where it's at?
Yes.
Okay, everybody's good on that. All right, so we're going to insert the bat 65 and ag bat as to Mr. Reeves. and then we start up with count 2.
Right, as to Mr. Oulson, the justifiable, right, and then we start count 2, aggravated battery, alleging Nicole Oulson is the victim.
Got it. And that's all good, that one?
That's good.
Yeah.
Okay. Possession of a firearm and discharge as to,
With one go.
okay, that's all good, except for that you're gonna take out the her.
Yes.
Yes, Ryan, on the aggravated battery, it's gotta have the 10-20 life limit. So murder second degree is 10-20 life, aggravated battery is 10-20 life, manslaughter is the enhancement.
Right. But it still has to have the interrogatory for it.
Yes.
Oh, right, on
Yeah,
the
that's the
verdict
verdict.
form, okay.
We'll get there after.
Okay, right. All right. I didn't even look at them yet. So then we've got felony battery as the lesser of
Right,
ag bat. Okay. And then simple battery,
right.
and then the transferred intent.
Transferred intent, now, we're gonna change that. We both agree that the justifiable use of deadly force language comes in on the second paragraph. So we're both in agreement as to that. However, where it says the death of Chad Oulson resulted from the justifiable use of force, then you must find that the aggravated battery
Okay.
or felony battery or battery of Nicole Oulson was also justified. So we're gonna add
Okay.
that language in to cover the lessers.
Okay, that seems fair enough. All right.
That's one that we'll edit.
Right, you're gonna edit that, okay, so plea of not guilty, that's all good?
Well, no, what we're requesting in the state is not objecting on that very last sentence. If you have a reasonable doubt, you shall find the defendant not guilty instead of should.
Okay,
And if you have no reasonable doubt, you shall find the defendant guilty.
that's changing a standard.
You know, I mean,
Well,
I said that I really would rather not change the standard, but if we were gonna change it one way, then we'll change it both.
Yeah,
But I truly don't like changing the standards.
I
Right.
understand that, but I mean, when you look at it, it's.
Well, I know, and I've read it hundreds of times, and I agree with you. It almost, it makes it like it's suggestive.
Exactly.
It does, it's like if the Ten Commandments change, you should not kill, you should not steal, I mean, they don't have the same force.
That's
All
what I
right.
said. I mean, I really don't like, I always default to the standards. just
I
because it's
agree.
so messed up.
I
And I
agree.
really don't, I mean, I can't say with certainty, I just don't think it's gonna be a big deal in this case.
I
don't
know.
think people read it like that.
Well, why did they say it like that, I mean, do we,
Judge, I think we're all intelligent lawyers, and we should be able to, it is shall. We should all be able to put it down and
all right, let's just do
And
it.
both sides are agreeing, Your Honor,
All right.
so it's not like, let's say we ask for it,
I
and
know,
then we get the wrong verdict, now it becomes,
right, I
now
know.
it gets changed for the wrong reasons.
Well, I can tell you, in all my years, I've only had one polling of the jury where they said no, so, and I think that's where it would come up, and you should, but we didn't, So I don't know, but all right. Well, without further ado, I'll agree to it. Shall can go in there. All right, and
Weighing of the evidence,
yeah. What
Take out-
about
Taking out number 7.
right,
7? Just 7? What about 6? Was there
I
any
didn't think it
evidence
really
of that?
applied. Since I don't think it really applied.
I say take it out.
All right,
Yeah.
take it out.
Yeah, I had 6s coming out, and the other ones you've already taken out.
Yep.
9 and 10. Yeah, 8 needs to stay. Okay, and then number of witnesses, that's given all cases. Law enforcement expert. How about defendant testifying? Yep, that's in there. And talk to lawyer. Okay, so that's all good. Then we got defendant's statements, correct. Rules for deliberation, yep. Okay. What about, oh, there it is, okay, yep, cautionary, I was looking for the single defendant, multiple counts. Okay,
And while we're discussing these changes to the jury instructions, I would ask that Mr. Reeves on the record indicate that he agrees with his attorneys and he also agrees with the changes that we made maybe at the very end.
okay,
Well, I don't know if that's necessary, Your Honor. I mean, he's present, his lawyers are present, so they're competent. I mean, I
we've
don't know
certainly
if
got a
that's
record.
necessary. We're not asking to.
I just always suggest an abundance of caution.
Okay. All right, I can do that. You know, I didn't ask Mr. Reeves about his decision to testify. It's a little late now, but
Yeah, he was gonna testify from the very beginning.
I knew that, but
Yeah.
I still should have
Yeah.
asked him, but I did not. But, all right, so,
We have
Mr.
single
Reeves?
counts, then the last one, submitting the case to the jury. This is the 2021. But
Okay.
it includes other electronic devices that weren't listed under 2014. So that's the one we're gonna use.
Where does
Cell
it
phones,
say other
tablets.
electronic devices?
The third paragraph.
Yeah, tablets, cell phone, laptops.
Okay.
So we're good with that.
All right, and as far as A or B, I discussed it with my bailiff, the firearm, does anybody wish to have that back without question, or there's no bullets, no live rounds, so it can go back? I was gonna say if you wanna see it,
Yes. You know, that it's available, and then if you
Right.
see it, and there's the bullets don't go back with the gun, and vice versa, and we have it available, and we'll have to switch out things, or...
Yeah, I'm fine with that. If they want to see if they can ask for it, I don't think that's something they can have it back there.
right, so I was gonna do that under B. These exhibits, I'll read A, or, I can say most of these exhibits will be sent into the jury room with you when you begin to deliberate. And then B, if you wish to see the firearm exhibit, please request that in writing. Good enough?
You feel good with that?
Yeah, fine.
Well, just so, because we're all tired, we can't put the gun back with the bullets.
Right.
We have to be able,
But there aren't any bullets, there's no live rounds.
I think there's more.
Is there? I didn't think there was. I thought all of them were spent.
All right, let's,
I'm almost positive there was 4.
I'm sorry, Judge, what's that?
there was more
There were
magazines.
4 spent cartridges,
Right,
and then there was the empty casing.
right, that's what I thought.
I don't
So
think
there were
there's no live rounds.
right, no live rounds.
There's one in the chamber.
Was there one in the chamber?
Oh, yeah, there was.
I was wondering where was the last one, but didn't they fire that one? 2?
I know they used the 4 in the magazine.
Yeah,
Let
Okay.
me look.
because, yeah, I mean, we'll have to, if they ask to see the firearm, we'll swap out, but we need to know what exhibit, if there is a live one. Let me see.
Staying here, so it's not like you can take anything
Do you have
You all, you can review other than justify the change the laws that we all changed. We'll edit those, and add the other one. Is that what you said?
No.
You didn't say that.
You guys are all doing, I mean, if you need me to, I will, I'll go upstairs and do it.
And that way we can send you the, if you want to, because we've got the justified use.
Did you send it, format that you sent it, I'll take your stickies off? Why don't you email it to me in the format that I can go
I don't know,
over?
guys, I have it saved in like such a crazy way, I have so many files,
Can you
it's so
just-
hard to find it, because I've done it 55 times.
Because we need to upload it, you know, obviously for our presentation.
Use my notes.
We can't edit it, debate on this.
All right, so what do you want me to do?
Send me something that you can edit.
Okay.
Okay, I've got number 30 is the 4 casings, 31 is the magazine, 32 was an open casing that had been the live round,
I got it.
now casing fired by FDLE.
See, the
Yeah.
bullet is not with the casing, and I remember seeing it.
Okay,
So there are 4 unfired and 1 unfired. And I got
okay,
it.
right, 4 unfired and 1 unfired,
Yes, ma'am.
or fired,
Yes, ma'am.
right, okay. All right, so we don't have to worry about that,
No,
so.
ma'am, you do not.
All right. All right, so that's it, right? Just those changes?
Yeah, we worked on the verdict form.
Okay, yeah.
Trying to get those done.
Okay.
And what was the final decision on the felony battery? Felony battery, all right?
No, just a battery on the 65.
Their felony battery is in here.
I know, but.
I have to battery too. I think it's justified.
Well, as in the justifiable use instruction? or-
No, I know what he's talking about now, and he's right. There's a lesser included for Nicole. It's a
Oh.
misdemeanor battery.
Right, well, you've got felony battery
It's a
and misdemeanor
misdemeanor.
battery.
Right.
The reason we're asking is we're doing the jury instructions.
No, I understand.
Yeah, and none of the enhancement doesn't apply to a misdemeanor.
Right.
I'm just trying to get the jury instructions. I'm going to be agree.
You just mean verdict form, but.
Verdict form,
Yeah.
right, I know.
The enhancement doesn't apply to a misdemeanor, so I didn't want her to put the interrogatory on it.
Okay. All right, so you got the verdict form?
And I need to take a look at it.
Okay.
So Judge, the copies, the changes that we've agreed on in terms of the standard jury instructions, aside from justifiable use of force and all that, we're going to change. Is the court going to edit those? You want us to edit those?
You
How do
can
we want to
edit
do
them.
it?
Whoever's editing, edit everything.
Okay, then we'll bring it in the
Yeah.
morning.
Right.
That's fine. Mr. Rosen wants
Right.
to try to get us a copy that we can edit,
Okay,
because I don't have his standards.
right,
And then we'll do the ones that we've worked on and the
Okay.
transferred intent one that we wrote up. And then we'll
Okay.
email each other copies this evening.
all right.
Okay?
And we can, we'll go over them, of course, one more time
Right.
before, out of the presence of the jury, and then do closings, and then, or I'm going to instruct, I already told them early on that I was going to instruct after closings, which is the norm, but I guess some people do it differently, so, but that's what I told them. They were going to get instructed after the closings, so.
Okay, so I'm gonna, which ones are you changing?
I'm sorry, what did you say, Scott?
Which ones are you changing and what am I doing?
If you give us,
Because I don't have all this typed out.
I know, you don't have what all?
Justifiable.
Just by use of that.
We'll do that.
You're gonna do that.
We'll do that. You just do the other ones, and give them to us tonight.
We can transfer it.
Okay. You have that 65?
Yeah,
And
we
you
have
have
that. We have annual, yeah, we have that.
So what we're doing now.
We're doing that.
So you want me to do this one?
Look at, yeah.
You want me to do this one?
Yes, please. And then take the numbers out, so you know, all the numbers and statutes and all that.
So nice to be able to do this without the jury sitting back there waiting somewhere.
You can tell they're tired, you know?
Yeah, they are. We all are. Everybody is. It's been a long haul.
Okay.
All right, we got it all straightened out, I think.
Okay.
I just need to see the verdict form.
All right, you look at the verdict form. I'm going to inquire briefly of Mr. Reeves, yeah. Mr. Reeves, I'm going to consider you still under oath, okay, but I just want to ask you one quick question regarding these jury instructions. You've been present during the entire trial, but during this entire process, since I've been sitting here, listening to our discussions, do you agree with these discussions that we've had about the verdict form, the jury instructions and the verdict form, or are you going to rely on your attorneys to make the decisions about these instructions? Okay, all right, but you have been present, so, all right. And you're not shy or anything to ask questions and tell them what about this instruction or that instruction if you so desire?
Correct.
You're good with that? Okay, thank you. All right, so are we good? Looks like we are.
We're good.
I'm liking where we're at.
If you're asking if we're finished, yes.
All right. Well,
Are we
yeah.
starting at 8:30 tomorrow, or is there any way to start at 9 tomorrow?
I told the jurors 8:30, yeah. But, we'll have a lunch break. Now, on that note, Mr. Rosenwasser, are you doing closings?
Yes.
Okay, so, any ballpark?
Here's why it's tough, is that if I decide to play the video, then it's just time to set things up and play
Okay.
it, so that's the only hard part.
Okay.
But what were you all thinking? I have two. There's so much information.
I'm thinking probably 3 hours.
That's what I figured. Okay. I was hoping if we could get the jury deliberating by 3 o'clock. I think that's reasonable expectation. I'm certainly not going to tell them anything, but I think we can do that. And I think that's a good time, they'll go to lunch on their own, and then after that, we'll let the chips fall where they may. We'll be prepared to feed them if we need to, and I'm prepared to work late into the night. We'll have to cross any bridge that as we come to it if it goes too late, but we'll like I said, we'll deal with that if we need to.
Just for planning purposes, if they do not come to the decision by Friday, are you planning to bring it back Saturday?
I don't think I can do that.
I would definitely not agree to that. I don't know if it's one of those things you agree with or not, but I've never had that happen. I would say to just keep going.
Okay,
Typically, we've always, I think the latest I've ever gone was 1 a.m. and they got a verdict, but I've never worked all night. I don't know about you guys. I've never worked into the next day.
I was just wondering if you bring it back Saturday morning.
Well, I know,
I don't get
but
around the clock.
No, I've never done that. I wouldn't suggest that either.
no, it'd probably have to be Monday morning.
I'm meaning that once they go to deliberate, deliberate until that we don't take a break while they're deliberating. They just deliberate. If it goes to 3, I've had verdicts come back at 3:30, 4 in the morning.
All right. Well, I've never done that.
That's putting, in my opinion, undue pressure on this jury that they don't need to.
They have to stay together, or sequestered.
That not in a second. They don't.
We'll drive off that bridge. We'll
Yeah.
drive off that bridge when we get there.
Yeah. Let's not.
Well, no, it's a first.
Well, it's
PBL.
PBL, but I think it's only in first degree that they have to be
I don't know the answer.
sequestered.
I've just never ever had it in my whole career.
I never have either. I have never had to stop.
Yeah, and I certainly wouldn't agree to it.
All right.
It's just, if you look at the last information,
Mm-hmm.
you change everything, it's a first life, it's not PBL.
Well, I'm almost positive the rule is, okay,
Just so
and,
you know.
but I think the rule is only in a first-degree murder capital case. They have to, I know that, they have to be sequestered. But I think that's the only time, so, all right, well, we're not
Especially on
even,
high-profile cases, there's so much news media, I just don't think it'd be a good idea. But we'll get there when we get there.
right, let's just,
We don't want to, something happens with a juror while they're out, and then this is for naught, I mean, that would just be terrible.
oh, yeah. Yes, indeed. So, no, we're probably not even gonna have to go there.
Judge, I'll have the verdict form tomorrow.
Okay, very good. All right, we'll call it a night. Thanks, everybody.